I'm Ben Meiselas from the MeidasTouch Network, and this is a breaking news alert. The Superior Court judge in Fulton County, Judge Robert McBurney, has ruled that portions of the special grand jury report that was created to make recommendations regarding criminal election interference into the 2020 election can be released and will be released on February 16th of 2023. However, based on the due process considerations of individuals whose indictments are likely to be imminent, the entire report will not be released. So let's dig into Judge McBurney's order right now. And what Judge McBurney says is the following. While there are these very significant due process considerations for individuals who may be indicted, whose names are in the report right now, we want to make sure that those individuals have all the due process rights afforded to them under the Constitution. However, pull this up right here. Judge McBurney says there are, however, 3 parts of the final report that are ripe for publication, meaning that there are 3 parts that Judge McBurney is going to release. He goes on to say, they do not implicate the concerns raised in Thompson and Kelly. Thompson and Kelly, those italicized words, are cases that involve protecting the due process rights of people's names who appear in grand jury reports. Judge McBurney goes on to say, and while publication may not be convenient for the pacing of the district attorney's investigation, the compelling public interest in these proceedings and the unquestionable value and importance of transparency require their release. The judge goes on to then mention the 3 parts of the special grand jury's report that are going to be released. He says the following. These 3 portions include the introduction and conclusion to the final report, as well as Section 8, in which the special purpose grand jury discusses its concerns that some witnesses may have lied under oath during their testimony to the grand jury. Because the grand jury does not identify those witnesses, the conclusions may be publicly disclosed at this time. So you see here, Judge McBurney's trying to balance what's in the public interest, even if the district attorney does not want it all released yet because of these due process concerns. However, at the same time, shielding the names of people who are mentioned in the report who the grand jury recommends to be criminally indicted. The conclusion of the judge's order says the following. Therefore, consistent with the special purpose grand jury's recommendations made pursuant to OCGA section 15-12-80, that its final report be published. Those 3 portions of the report will be placed in the docket for this matter, making those excerpts, but only those excerpts, a court record on the 16th of February, 2023. The several-day delay will allow the district attorney's team to meet with the undersigned if necessary, to discuss logistics of publication, and to determine if any portion of those 3 parts of the final report should be redacted for other reasons, notice of which will be provided in the 16th of February 2023 docket entry. Finally, the court directs the district attorney's office to provide periodic updates on the progress of its investigation so the court can reassess if other parts of the special purpose grand jury's final report can properly be disclosed, consistent with the analysis set forth above. And the analysis set forth above is the analysis in this 8-page order that Judge McBurney released saying, look, the special purpose grand jury that was impaneled in 2022 to investigate 2020 election interference, they voted. They made a recommendation to release their report regarding who they want to be criminally indicted. Just so you know, from those watching at home, in terms of the procedure here, the special purpose grand jury can make recommendations of indictment. Then those recommendations can go before another grand jury, which actually has the power to indict. So the special grand jury just prepares a report, doesn't have the power of indictment. Nonetheless, One of the things that Fani Willis had told Judge McBurney at the last hearing that took place a few weeks back was that indictments are imminent, meaning there's likely another grand jury impaneled that's utilizing this report as we speak to make a vote on those criminal indictments, to actually criminally indict the individuals who are mentioned in the report. Now, the special purpose grand jury made this recommendation to Judge McBurney that the report they prepared regarding who they believe engaged in criminal conduct, they want to release to the public. The Georgia statute uses the word shall, that if a recommendation is made by the special purpose grand jury, a judge shall, not may, shall release it. However, that has to be tempered by the constitutional due process rights to the individuals who may be criminally indicted. And one of the important points here that Judge McBurney points out, and this is where I think it's actually referring to Donald Trump. If we look at page 6 of 8 of Judge McBurney's order, he says these due process concerns are particularly important as they relate to individuals who may not have appeared before the special purpose grand jury. Who didn't appear before the special purpose grand jury who a recommendation may have been made to indict that individual? Donald Trump. So this is what it specifically says. Judge McBurney writes, this is particularly true, the due process concerns, that is, if the grand jury's final report includes recommendations involving individuals who never appeared before the grand jury and so had no opportunity, limited or not, to be heard. The court goes on to say, the constitutionally protected due process rights of anyone who may be named in the final report requires this outcome. So to me, when I read that, my red sirens went off and said that's probably referring to Donald Trump there as well. And then I thought there was this important footnote 2, which talks about the process of releasing the names and when the full report would ultimately be released. This is what footnote 2 says. That's why you got to dig, into these orders to really get the full context here. Later, this is footnote 2, later, when the criminal investigation is complete and an indictment has been obtained, the wiretap application and the search warrant affidavit do become part of the court record through discovery and pretrial litigation. At that point, the public's right of access accrues. The special purpose grand jury's final report is no different. So comparing this to other grand jury processes, which usually take place in secret, and when does that information become public? And what the court is saying later, when criminal investigation is complete and an indictment has been obtained, the wiretap application and the search warrant affidavit become part of the court record through discovery, and then the public gets access to that same thing with the special purpose grand jury's report. And so to summarize it very quickly, portions of the special purpose grand jury's report recommending criminal indictments is going to be released. However, portions which actually state the name of the people who are recommended to be indicted are not going to be released. It's going to be limited to 3 parts that are set forth in the court's order that do not implicate due process concerns. This is the introduction and the conclusion and Section 8, which talks about the grand jury's view that some of the witnesses committed perjury, but that portion does not list the actual names of the witnesses who the grand jury believes committed perjury. This will be released. These 3 portions are going to be part of the public record. They're going to be released on February 16th of 2023, so it's coming up this week. Separately, the Fulton County District Attorney, Fani Willis, is being told, report back to me, Judge McBurney. Let me know your status, because the reason I'm not releasing the full report is the due process concerns, because you're telling me you are about to start criminally indicting people, and we want to protect the integrity of the criminal investigation. But if anything changes, let me know. So I think criminal indictments from Fani Willis are imminent, and I do think, though, while we're not going to get a lot of information from Judge McBurney this week, it's still going to be very important and very powerful information. I'm Ben Meiselas from the MeidasTouch Network. Hit the subscribe button. We are on our way to 1 million subscribers thanks to your incredible support. So please hit the subscribe button right now. And in addition to hitting the subscribe button, check us out at patreon.com/MeidasTouch. You will love the exclusive content we have on our Patreon site. But most importantly, it helps grow this independent media platform. That's patreon.com/MeidasTouch. While you're at it, check out the show Killing County on Hulu that I executive produced with Colin Kaepernick. It's about the crime, corruption, and cover-up that takes place in Bakersfield, which just so happens to be Kevin McCarthy's district. Again, hit subscribe. Thank you so much. I'm Ben Meiselas. Until next time.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.meidastouch.com. That's store.meidastouch.com.